If it pleases the court, I act on behalf of the defendant. My name is Moorhead, M-O-O-R-H-E-A-D, initial M. I'm instructed by Slaw & Cole lawyers. The dispute concerns three clauses of the agreement. I'll address each in turn, keeping in mind, Your Honour, that following Garrity and Minter, a 1979 case at volume 142 of the Commonwealth Law Reports, page 133, paragraph 6, the courts would take a less favourable view of a restraint of trade clause between an employer and an employee than between a purchaser and a vendor. I'll now address clause 12. In Cactus Imaging Proprietary Limited and Glenn Peters, a 2006 case in volume 71 of the New South Wales Law Reports, at page 9, paragraph 14, confidential information must be capable of being identified with specificity and not merely in global terms before such a restraint will be held reasonable. Critically, clause 12 does not specify a duration period for the restraint. Consistent with RBM Plastic Extrusions Proprietary Limited and Diaz, an unreported 2006 New South Wales Supreme Court case, case number 1332 at paragraph 18, an indefinite restraint, particularly in an employer-employee relationship, is almost inevitably excessive. Clause 14a. In Burdanko Nominees Proprietary Limited and Money, a 2012 case at volume 36 of the Victorian Reports, page 341, paragraph 46, Acting Chief Justice Robson, quoting the Honourable Justice Dyson with approval, held that in regard to non-solicitation clauses, the important thing is that the personal relation between the employee and the customer be such as to enable the employee to control the customer's business as a personal asset. The relationship with clients must not be characterised simply as one of mere contact per se, but an intimate personal relationship. Further, as discussed in Linda and Murdoch's Garage, a 1950 case, volume 83 of the Commonwealth Law Reports, page 628, the customer must be a recurring one. Clause 14b. A mere material business dealing with another employee is not a sufficient interest requiring protection. In Aussie Home Loans and X-Inc Services, a 2005 case in the New South Wales Supreme Court, case number 285 at paragraph 25, the requirement is that there is knowledge of the qualifications and rates of remuneration and other such confidential information of employees. Clause 15. The extension of the clause to competitors of group companies, in addition to those of Fossil Fuels or Us, imposes a restraint that is wider than necessary to protect the legitimate interests of the company. In Just Group Limited and PEC, a 2016 Victorian Supreme Court of Appeal decision, case number 334 at paragraph 54, it was held that the plaintiff in that case failed to justify a similarly wide restraint in a similar factual scenario. In OAMPS Insurance Brokers Limited and Shackcloth, a 2008 Northern Territory Supreme Court decision, case 29 at paragraph 59, the court emphasised the need to protect the legitimate interests of businesses must be balanced against the rights of a person to work in their chosen profession without unnecessary or unjust restriction. It is submitted that clauses 12, 14 and 15 are unreasonable in their present form and go further than necessary to protect the plaintiff's interests and are therefore void. Such restraints are not reasonable in the public interest in line with Just Group Limited and PEC at paragraph 31. If the court finds that the clauses are valid and the defendant submits that the words group company be severed from clauses 14 and 15, in line with the Blue Pencil rule established in Nordenfelt and the Maxim Nordenfelt Guns and Ammunition Co. Limited and 1894 case in the appeals cases at 535. It is further submitted that injunctive relief for a breach of clause 15 would significantly disrupt the operations of Black Gold and innocent third party, and damages should be awarded instead. A position supported by Capgemini US and case, a 2004 decision in the New South Wales Supreme Court, case number 674 at paragraph 43.